First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have two consolidated cases on the docket today, and I understand the lawyers have been informed that they're going to have essentially 20 minutes per case, 10 minutes per side for the two cases. We'll begin with State Farm Insurance versus Lightfoot and Hunt. Is the appellant ready to proceed? You may proceed.
Thank you, Your Honor. Just to clarify, I think the arrangement was that 20-2303 would be the
I'm
one
sorry,
to
we'll go first. You're right.
All right.
Forgive me. And you can pull the microphone down, so we'll do that case first. Hunt
Right.
versus Lightfoot. Is the appellant ready to proceed?
Yes, Your Honor.
That's you.
That's
all right.
Thank you, Judge. I'm Warren Kwabnik. I represent the appellant Marilyn Hunt. I want to thank the court for extending our oral argument time today. I think we all appreciate that. Again, I represent Marilyn Hunt, who is the defendant in the lower court. Mrs. Hunt is represented by other counsel, Mr. Green, in connection with State Farm's appeal, which would be argued next. I'd like to reserve...
Can you pull the microphone a little closer, perhaps?
Okay. Is that better?
That's better.
Thank you. I'd like to reserve 2 minutes for rebuttal, please. A proposal for settlement. The assessment of attorney's fees under a proposal for settlement is a punishment. It's a sanction for not accepting the proposal. In part for that reason, case law has established that the rule in the statute should be strictly construed. In addition, when the offeror chooses to include a condition that it turns out the offeree cannot accept or cannot unilaterally accept, it invalidates the proposal as a basis for the assessment of sanctions. And third, the other broad principle that I think is applicable here is the statute provides that when a proposal is not issued in good faith, it cannot furnish the basis for sanctions. Now, in this case, the problem with the plaintiff's proposal for settlement was it included a condition, a term, which they did not have to include, that required as a precondition to the existence of a settlement, Mrs. Hunt had to tender $1.3 million, which was well in excess, of course, of her $50,000 insurance policy. Now, we've addressed the invalidity of that provision from a number of different angles in our brief. To the extent I can't reach them all today, I'm going to have to rely on my brief. But the two primary ones are that this resulted in what the case law has recognized as an impossible condition, and secondly, that it resulted in a bad faith condition. Now, the analysis for both of these is a little bit different, and I would start by pointing out that we've cited, with regard to impossibility, we've cited in our brief a handful of cases dealing with impossible conditions, and I would ask the court rhetorically, compared to those cases, why is Mrs. Hunt's inability to pay $1.3 million any less real of an impossibility than the impossibility that was found to exist in those cases? In the Gonzalez case, for example, it was held to be an impossibility that it was impossible for the offeree to comply with a condition requiring that his insurance...
So is your argument that Mrs. Hunt was not able to accept the offer of settlement because she was not worth $1.3 million. There was no way she could ever get 1.3. Or is your argument that it was impossible because of the terms, the way it had to be settled? For instance, if it would have said Mrs. Hunt is required to sign a settlement agreement or enter a promissory note within 30 days, would have that been different? And is your argument basically because it's cash on the barrelhead?
Yes.
Okay.
Yes, it was an impossibility, and let me clarify this a little bit. If under the Paduru case,
because looking at the case law, I'm having trouble with it. If the argument is that there's no way she has this money. She's not worth this much money. I don't see that as a very compelling argument. But if the argument is, that even if she had means, most people can't come up with $1.3 million cash in 30 days. Most people's, even wealthy people, their wealth is in their home or their 401k, or it's tied up in stuff that they would have to make arrangements to sell. And as a practical matter, it would take more than 30 days to raise the money.
We've included an argument in our brief that a proposal for settlement, in order to support sanctions, can never include a condition of actual payment. We've made that as a broad argument, for the reason that.
Why not? Why, if the defendant is, Scrooge McDuck and he has a vault full of money that he rolls around in every day, that would not be impossible.
Well, that's different from the impossibility argument, and we've raised both. Mm-hmm. And with regard to the broader
well, that
argument,
wouldn't be in bad faith for someone that that has that.
Well, if they can pay it, and the plaintiff has a means to know that, it's not a bad faith condition, but it is in this case. And like I've said, we've addressed this from different angles. With regard to the broader position that you can never include this type of condition, I would say that you cannot, because a proposal.
Asking an appellate court to write opinions that say you can never ever do something that's a pretty big lift.
Well, it is, and I wasn't even planning to address that in the oral argument today, because I think we can decide this case on the narrower grounds that we've addressed in our brief, which is assuming this is a valid condition ever, by having chosen to include a condition of actual payment that they didn't have to do, the plaintiff bears the burden of showing that it was something that was possible to be accomplished in this case. I think this case fits squarely within the ones Paduru, Gonzalez, and Daisadu that say.
Well, in Gonzalez, aren't those cases distinguishable because they required payment by the insurer? It wasn't just a PFS that dealt with the defendant.
Well, it was a different, right, the impossibility was not quite exactly the same as it was here on its face. But that's why I began by saying, why is Mrs. Hunt's impossibility any less real than the impossibility in those cases? If we're going to invalidate a proposal because an offeree can't compel.
Well, I got Gonzalez here. It says we conclude that the proposal for settlement was invalid and unenforceable because it was impossible for Gonzalez to meet the conditions of the proposal. And that's your thesis. But it goes on to specifically say what they say. Specifically, the proposal required that Geico, a non-party, tender a check well in excess of its policy limits of $25,000, even though there had been no determination that Geico is liable to pay more than the policy limits.
Right. Yes, that was the type of that was the impossibility there. Ours is not the exact same type of impossibility. But again, if you look at some of the other cases, if you look at Daisadu, what happened there was a proposal for settlement to a plaintiff that would have required him to sign a release that contained a false statement regarding the existence of beneficiaries. That too is said to result in an impossibility. So the types of impossibilities are situations where the offeree cannot perform what's being offered them. I would submit that, yes, each of these cases was not exactly the same thing we're dealing with here, but our situation, I think, is governed by those cases. Each of those cases, and ours, involves a situation where the offeror chose to include a condition that didn't have to be there. Nothing in the rule or the statute requires the conditions that were at issue in those cases or here, and it resulted in a situation for any variety of reasons. So
what if the offer would have required Mrs. Hunt to sign a promissory note for $1.3 million?
I would say that that's probably that's leaving aside our per se argument. Mm-hmm. I would say that you wouldn't have the same type of impossibility problem there. In fact, I would say that that's along the lines of what the Alexander case says should happen in these cases. The Alexander case is a decision that says the defendant didn't have to be able to afford it. He or she could have accepted it anyway. The court retains jurisdiction and presumably would have enforced the settlement by entering a judgment. And I think that's effectively what Your Honor is suggesting would happen here. Yes, I think it probably would have been possible for her to enter into a promissory note. She likely would have wound up defaulting on it, and that would have resulted to a whole other set of issues. But
so Mr. Lightfoot has an $11 million judgment against Ms. Hunt, and at some time there's going to be collection proceedings on that.
Correct, and and the case law indicates if one of the policies behind the proposal for settlement statute is to short circuit litigation, we're right now where we would have been had they issued a proposal that was capable of being accepted. She could have accepted it. If she couldn't have paid it, a judgment could have been entered. This is the framework set forth by Alexander. What happened here is they've included a condition that couldn't be accepted. Under what basis? What basis is there to punish Mrs. Hunt because they served a proposal that couldn't be accepted by including a condition that everyone knew in reality couldn't be accepted? And I would emphasize that point, that unlike the bad faith analysis, where I acknowledge we have the burden of showing on the record it was in bad faith, I would submit to the court that if they choose to include a condition in their proposal, it's incumbent upon them as the party seeking sanctions to demonstrate this was a doable condition. Their whole argument is we have no way to do financial worth discovery on the front end. Well, then they roll the dice when they put this in a proposal for settlement as a condition of actual payment that they don't have to do. And in reality, you didn't need financial discovery to know Mrs. Hunt couldn't do that. The only thing we've heard is maybe she won the Powerball. And in terms of whether this is a good faith or a bad faith proposal, the case law says a proposal, we consider whether there was a reasonable basis for the proposal and whether there was intent to settle. When you're when you're interpreting, when you're applying that to the condition we have here, what was the basis that they had to believe she could accept this? Their whole argument is we had no way to know. Well, under the Eagleman case they cite, if you fire off a proposal blind with no reason to know that it can be accepted, or it has any connection to the case, it's not a good faith proposal. So their own argument that we had no way to know, I think, demonstrates that including a $1.3 million payment condition was not in good faith. It was not meant to result in a settlement. I'm well into my rebuttal time, so I'll save the rest for rebuttal. Thank you.
May it please the Court, Rebecca Creed on behalf of the appellee, James Lightfoot. Appellant cannot cite this Court to any authority that renders the financial ability or inability of the offeree a relevant condition or any aspect of that that is determinative of the validity of the enforceability of the proposal. Under the case law, a proposal is enforceable and a plaintiff or an offeror is entitled to fees if there's a determination of a valid proposal for settlement that is rejected and the judgment obtained is at least 25% more than the offer. There's no analysis of whether at the time that the proposal was served you had to consider the financial ability or inability of that offeree to accept. And the cases that they cite.
Well, I think their better argument is that not that you have to consider the financial ability of the offeree to settle the case, but whether it's reasonable to think anybody could have met that requirement. You know, and I asked that question to him, and I'm going to ask it to you. I see a substantial difference if they would have been required to, sign an offer of judgment or enter or a promissory note or something like that than asking someone to come up with $1.3 million cash on the barrelhead. Even what most people would consider wealthy people can't do that, and that's why it seems impossible to me.
Respectfully, Your Honor, the condition, the rule itself allows for conditions in non-monetary terms, and those are enforceable as long as they're stated with particularity. And so this type of particularity to tender with payment in exchange for dismissal is a condition or a non-monetary term that's commonly accepted and enforced and used in settlement agreements, and that's the language that we've essentially adopted here. The focus should be not on the reasonableness of the defendant's rejection. Under the TGI Friday case, the reasonableness of the rejection is not a determining factor as to entitlement. So the defendant could have been entirely reasonable.
And the rejection of this offer was not tendering within 30 days $1.3 million.
Yes, that the offer expired without anyone accepting. And so this condition was stated with particularity, and there's certainly we were not required to include this condition, but we were certainly permitted to include a condition or a non-monetary term under the rule itself.
So is your argument basically that, assuming that it was impossible for her to pay the $1.3 million, as I recall, it was not a particularly valuable vehicle, and there was the comment about the Powerball. So just if it was impossible for her to pay the $1.3 million, is it your kind of underlying logic that, okay, look, you had an insurance policy, you inform your insurance company has to take into account whether there's going to be a large judgment in this case, and if there's going to be a large judgment, whether they're going to be subject to bad faith litigation, and therefore the insurance company could have cut the check?
That is certainly an underlying consideration as discussed, especially in the State Farm appeal. Our proposal here is enforceable, though, because it wasn't directed to a non-party. It wasn't directed to State Farm. And Ms. Hunt could have had the ability to independently accept that and use her own funds.
But what if there was no way she could pay the judgment, the offer.
That doesn't render the offer impermissible, though, or invalid.
So in other words, she could have said, I accept your offer, I will pay you $1.3 million. Assume she had said that. I accept your offer, I will pay you $1.3 million, and day 31 arrives and you don't receive a check. Is that a rejection?
That is a rejection, and also I would say that the terms of our proposal were very specific in that it wasn't as if she could say, I accept, and then I'll tender. It was dismissal with prejudice conditioned on the tender of payment.
Well, what if she had said, I accept, but I can't give you cash in hand, I'm going to need to go get a loan, so I accept, can you wait a few days or work with me on payment?
I think that would have been a counteroffer, and then it would have been up to the plaintiff to decide. It wouldn't have been an acceptance, though, under the terms of this proposal. And
So the purpose of these proposals for settlement are to encourage settlement, correct?
yes.
Okay, well, it seems like in some of these cases, I'm not going to say that particularly in this case, but in some of these cases, some of these offers are set up in a way where it's clear that no one is really seeking settlement. They're just seeking a mechanism for fees in the end.
Respectfully, that is, to the extent that those arguments are in play, that would be just directed to whether this proposal was made not in good faith. And here there was a determination by the trial judge to reject any argument that it wasn't made in good faith. You look to the intent of the subjective intent of the offeror, which is a determination, the good faith considerations are whether the proposal was made with some reasonable expectation of settlement, and whether there was some
Well, did that
reasonable
exist here,
foundation.
that there was some reasonable expectation that Ms. Hunt could have come
There-
up with $1.3 million in 30 days?
Excuse me. That burden is on the offeree here to show, and there was nothing to show that there wasn't a reasonable expectation. Had that proposal been met, then yes, this case would have settled, and it would have avoided 4 years of litigation. The offer itself was about 10% of what the ultimate value of the claim was, and so the trial judge looked to that and said, well, it appears to me that if you decide to settle or offer to settle for 10% less than the total value of what ultimately turns out to be the worth of this case, then that's a reasonable offer made with the understanding of the facts that the plaintiff knew at that point in time, given this defendant's potential liability in a rear-end collision.
It was reasonable for the offeree to expect that a jury would award $10 million in pain and suffering?
I believe that it's,
I know we're not getting into the underlying judgment, obviously, but
well,
as I recall, the injured party got out of the car, and it didn't appear to be a massive injury, and the $10 million non-economic damage award was vigorously litigated.
It was vigorously litigated, and it was affirmed on appeal. And so, yes, I think that offeree could have anticipated a significant damages award, given that she did rear-end Mr. Lightfoot, that there was at least a presumption of negligence, and there was significant treatment and surgeries, and that's part of why, and also considerable delay in the years between the filing of this lawsuit and the trial. So all of those led up to the value of this case, and those were certainly a consideration. So the trial judge did not abuse her discretion in finding that there was no showing that this offer was not made in good faith. And to the extent there's any consideration of financial ability or inability at all contemplated, that would be the only aspect of the rule in which it should be considered. Again,
So I guess your argument is, under the statutory language, it does not provide an escape hatch for the offeree, that they don't have the ability to pay the offer.
That's correct, because this is not a situation like Paduro and Gonzalez, where the condition was outside of the offeree's control. There's a difference, even to the extent that these impossibility of performance cases are analogous, which I think even the defendant suggests in her reply brief that maybe it's not appropriate to look to those because there was no contract here. But even then, there's a difference between saying, I can't do something and something legally cannot be done. And that is the distinction between what this defendant is saying here. She says, I couldn't afford it after the fact. I couldn't afford it. And there's a difference between that and saying, well, this is a condition that was impossible to have been met because it required her to exercise or obtain control over another entity or individual who may not have even been a party to this action. And these cases that they cite all rest on the Florida Supreme Court's decision in Gorka, which again looks to whether you deprive the offeree of independent control to evaluate and settle a case. These are not the facts. These are not the facts of this case. It was clearly directed specifically to Ms. Hunt.
So
it
no
was
court
within
has,
her control.
so no court has actually addressed this specific issue here regarding when an offer is made and the offeree cannot pay the offer. They literally just cannot pay the offer. They do not have the assets, whether that's a valid offer. Is this a case of first impression?
I would argue it is, and it's a case of first impression that attempts to force impossibility conditions that may exist in other circumstances onto this set of circumstances that this defendant says are impossible for me to meet.
So your argument is the text of the statute, under the text of the statute, without elaboration or of shall we say, creative court decisions, you win.
Yes, Your Honor, it is. It's the plain language of the statute and the rule which allow conditions in non-monetary terms, don't prohibit them, but certainly don't require this plaintiff to evaluate the financial ability or inability of a defendant or an offeree before serving that offer. I would also reject any notion that there's some kind of categorical invalidity based on a lack of preservation, and also the fact that, again, it just looks to case law that does not fit here, and that there's never been a determination of categorical invalidity based simply on tender of payment. And again, this kind of condition and non-monetary term is specifically
I guess a policy
allowed.
argument in your favor would be get bigger insurance policies. In other words, for parties that drive on the roads, if there's a concern that you don't have the assets to pay, then rather than have a $50,000 policy, have a $3 million policy. Anyway, I've expired your time.
Thank you.
I'll add a minute 40 to the appellant's time, please, Madam Clerk.
Thank you, Your Honor.
Thank you for your argument.
The reason why, yes, it's true. The statute and the rule don't speak of an escape valve for financial inability because the statute and the rule don't speak of a payment condition to begin with. It's the rule, not the statute, mind you, that allows non-monetary terms and conditions. And I would say to the court that under the conventional proposal for settlement, yes, financial ability to pay or not pay should have no part in this analysis. But when the offeror chooses of their own accord to add a condition of actual payment as a precondition to the formation of a settlement, they've made it an issue. They've made possibility an issue, and I disagree with the notion that the case law limits impossibility to what they're calling certain legal impossibilities. The Daisadu case was a person-specific impossibility. It was impossible for the plaintiff to sign a release saying he had no dependents who could have sued for loss of consortium. A different plaintiff could have signed that truthfully.
Just for clarification, obviously there's payment in there's a payment aspect or element in every proposal for settlement. So specifically, is it your position that it takes it a step further by saying, I want cash on the barrel in 30 days? You have, by narrowing it to that specific, that's what takes this.
I don't know if the 30 days is the issue, but a precondition to the existence of a settlement agreement, the case would not settle unless there was actual payment, is what makes the difference. And I want to be clear to the court, yes, it is an issue of first impression. This will not create a parade of horribles. This will not create a slippery slope. We're not dealing with every proposal. We're only addressing a proposal for settlement where the plaintiff chooses to put in a condition of actual payment. That's not in the conventional proposal for settlement. They don't have to do it. My argument is if they're going to make a precondition to the existence of a settlement that you actually tender 1.3.
How does that offer fail under the text of the statute or the rule?
It fails.
Tell me the text under which the textual argument in your favor.
I'm going to have to rely on the case law for this. The case law that says that we construe the statute and rule narrowly and strictly against the offeror and the imposition of sanctions because it is a sanction and it is in derogation of the common law. And because of these things, when the offeror chooses to include a condition that cannot be performed either because of person-specific circumstances or legally or otherwise, we're not going to use this as a basis to impose sanctions.
All right, well, I've allowed you even more additional time, which I think we're all being fair here, so.
All right.
I'll ask you to briefly conclude.
We'd ask that the court reverse the imposition of attorney's fees. Thank you.
Thank you, counsel. All right, I guess we'll have a little bit of musical chairs here. We'll go to the second case. The first case second, State Farm versus Lightfoot and Hunt.
May it please the court, James Michael Shaw Jr., Butler, Wymuller, Katz, Craig, LLP for the appellant State Farm Mutual Automobile Insurance Company. I have 10 minutes and I'd like to reserve 3 minutes for rebuttal, please. I have 3 points that I'd like to make. The first one is just that I agree with Mr. Kvobnik's position that these fees never should have been awarded in the first place. The plaintiff knew perfectly well that.
So if we reverse on the second case, you win automatically.
My case becomes moot, the question of whether or not the fee award is covered if there's no fee award in the first place. And so with that aside, I want to jump to my second argument, which is that subsection 4 of the non-joinder statute was never designed to create an adversarial proceeding that's resolved on a post-trial motion. The reason for subsection 4 of the non-joinder statute is where coverage is undisputed, it streamlines the process of adding the insurer to the judgment. It used to be necessary before subsection 4 was enacted in 1990 to file a separate action against the insurer. Subsection 4 made that unnecessary, but it was not designed where coverage is disputed to collapse an entire declaratory judgment action into one post-trial motion that gets a half-an-hour hearing or a 1-hour hearing at the end of a case. My client disputed coverage. We don't interpret the policy language the way that the plaintiff interpreted it, but that dispute should not have been resolved on a post-trial motion. That dispute should have been resolved in a separately filed action. I know that the appellee has pointed to the text in subsection 4 that cross-references the Claims Administration statute, section 627.426, subsection 2. If you look at the text of that statute, though, that statute is prohibitory, not compulsory. It states, a liability insurer shall not be permitted to deny, a double negative, shall not be permitted to deny based on a particular coverage defense unless, and then it doesn't matter what the unless is because it's not a coverage defense. When there's no coverage in the first place, it's not a coverage defense. That was AIU v. Block Marina, which was decided in 1989 by the Florida Supreme Court, 1 year before subsection 4 was enacted. So the legislature knew, or is presumed to have known, of the Florida Supreme Court's interpretation of the Claims Administration statute when it cross-referenced that statute in enacting subsection 4. So the argument that if there's no coverage at all, it can still be added, but if coverage is denied under the Claims Administration statute, which applies only where coverage already existed and was forfeited, that statute requires notice to be given to the insured before the carrier can raise that coverage defense. But under AIU v. Block Marina, it's not a coverage defense if there was never coverage in the first place.
Yeah, since we're on limited time, could we skip to, I'm interested in discussing the Spiegel, Florida Supreme Court case, which said that unless the statute says that fees are included as costs, you don't get fees under the cost category. And it seems like there's a split in the districts, and pursuant to my study, our court has not specifically made up or stated a position on this, but how do you mesh Spiegel in this case with the argument of Mr. Lightfoot that it's all a focus of policy language and contract interpretation?
It is all a focus of policy language and contract interpretation, but starting with Spiegel. Spiegel acknowledged the Barrs case from 1924, which itself acknowledged older cases. So for over 100 years, the terms costs and court costs are not understood to include attorney's fees. There are some cases that have the word costs in a policy where courts have held that it was covered. If you study those cases, each one of them contrasts the word costs with another word that made it ambiguous. The word costs by itself is not ambiguous. No court has held that the term costs or court costs includes attorney's fees. But for instance, in Geico versus Macedo, the Florida Supreme Court's 2017 case, the term court costs was used under an index heading that said legal expenses and court costs. And so the court looked at the term legal expenses and said, well, that implies that there are legal expenses that are not court costs, and therefore it's
In your
ambiguous.
position, what's the appropriate analysis here? When I study that line of cases, we've got the Middle District, who to me is strictly applying Spiegel, as it should up to today. We've got other cases from other districts in which there's no mention of Spiegel, and it's strictly a analysis of contract language and policy language. So what is your position with respect to how Spiegel's still good law?
Excuse me.
How do we apply Spiegel and arguments about going into policy language? How do you mesh those two, and what do you think is the appropriate analysis legally?
Sure. Spiegel is still good law, and Spiegel holds that attorney's fees are costs only when there is a statute that designates them as costs. And there are statutes that do that. Spiegel itself cited Section 713.29, which states that attorney's fees must be taxed as part of the prevailing party's costs. So they're fees, but that statute says when awarded under this statute, they're considered costs, even though they're fees. Spiegel holds that the word costs can mean fees only in that circumstance and in no other circumstances. State Farm's policy is written differently than the policies that have interpreted the word cost in conjunction with other terms as ambiguous and then construed that ambiguity against the drafter. State Farm's policy doesn't suffer from that same ambiguity. State Farm's policy says court costs of any suit for damages, so the term court costs has never been held by any case to be an ambiguous term all by itself or to include attorney's fees all by itself. The other language that was relied upon by the plaintiff appellee and which was at issue in the Macedo case is reasonable expenses incurred by an insured at our request. In Macedo, there was a proposal for settlement that was lower than the policy limit, and Macedo looked to who had the right to decide whether or not to accept that. And it stated explicitly in the Macedo opinion that Geico did not have to ask Lombardo, the insured, to accept or reject the settlement offer because it was
Right.
within.
I don't think Macedo applies here because you tendered policy limits. So in the PFS was obviously well above policy limits, so we don't have an influence of State Farm on whether this went to trial, correct?
Correct. My client had no way could not have obligated its insured, Ms. Hunt, to come up with that money. State Farm didn't have the power to accept that proposal for settlement on her behalf and then tell her that she has 30 days to come up with $1.25 million cash on the barrel. That wasn't something we could have done, and she didn't have a mechanism to make us pay above our policy limit. It was her decision. Below the policy limit, it is the insurer's decision whether to accept or reject the offer. Above the policy limit, that is the insured's decision. I do need to talk about the Davis v. Murrow case because that one was a proposal for settlement above the policy limit, and cited to the Macedo case. However, the Davis v. Murrow case does not quote the policy language, and these cases are very policy language driven. Macedo did not announce a blanket rule that regardless of what the policy language is, the PFS fee awards are covered. Macedo turned on the language of that policy, which contrasted the word court costs with the word legal expenses, and the court held that because of that contrast, there was an ambiguity to be resolved in favor of coverage. State Farms doesn't have that legal expenses heading language that was in Macedo. Davis does not quote the policy language that it was referring to, but it was not following a blanket rule that these are covered now regardless of the policy language. The policy language still very much matters. It's not in the opinion. If the court wants to read it, it's in the brief. You can write a policy that says it's covered whether we request it or not, but State Farm's policy says it's only covered if we request it. And that word request was interpreted in Macedo as meaning where the insurer has the control over the decision to accept or reject the offer and rejects it, then the insurer has, in a sense, requested that the insured incur PFS fees in the event that the verdict comes in 25% more than the offer. That takes the definition of the word request very far from its common meaning, but it does make some level of sense where the proposal for settlement is below the policy limit. This one was far above the policy limit, and State Farm didn't have the obligation or to pay that money itself. To pay $1.3 million to avoid paying $1.2 million is not a real choice. It is a pay or pay abrogation of the policy limit to put us on that. So above the policy limit, it's up to the insured whether or not they want to incur that obligation. And State Farm didn't have the ability to make her do that or not. It wasn't State Farm's request to reject this offer, which could only be accepted by $1.3 million cash on the barrel that most, even wealthy people, would have trouble doing. Certainly somebody with a special needs child driving a 15-year-old car at the time of the car accident. So in summary, the PFS fees never should have been awarded in the first place. The plaintiffs knew perfectly well that she was unable to comply with the terms of this condition, and that's why they were there. So she couldn't comply with them, so they can be a fee award at the end. But even that aside, it's not covered by the language of the policy, and this dispute never should have been tried to resolve in a post-trial motion in the first place. Where there's a dispute as to coverage, the court should have denied the motion, and then the plaintiff could have filed a separate declaratory judgment action. And I'll save the rest of my time for rebuttal.
Well, you didn't save any time for rebuttal, but
I thought I said 3 minutes.
Well, you used it all.
Oh, I did.
But
All right.
I'll allow you to have 1 minute on rebuttal, and we'll give the appellee 11 minutes.
Thank you, Your Honor.
May it please the court. Good morning, Your Honors. My name is Danny Green, and I represent State Farm's insured, Mrs. Hunt, in this aspect of the appeal. As counsel said, there are two issues before the court.
I'm going to ask this question of appellant when he returns.
Sure.
And it's an unusual question, but aside from the contractual liability, State Farm could have paid the $1.3 million, right?
Correct, Your Honor. And that's
Nothing prohibited State Farm from, other than perhaps internal policies. I mean, you can't ask questions in this case without reference in the other case, and that's why I'm glad they're consolidated. The State Farm could have evaluated the situation and said, well, obviously you only bought a $50,000 policy, but we sense danger at the end of this litigation road, so we're going to pay the $1.3 million offer on your behalf. State Farm could have done that, right?
precisely, Your Honor, and that's an important point. Under the State Farm policy, State Farm was the only person who controls settlement decisions, and that's just under the plain language of the policy, and the cases all cite to that. The Gray case discusses
I don't know
it.
off the top of my head when this offer was made in terms of the date of the accident. Was it a year later, 2 years later?
I think this one may have been several years later.
So by that time, there was extensive litigation, I assume?
Yes, there had been extensive litigation, and actually
Including the issues that were raised in the first case about the plaintiff and the motorized wheelchair and whether there could be a compulsory medical exam. All those issues were out there, right?
As far as I know, Your Honor, I can't speak directly to the timing of what exactly was known at the time of the proposal.
So is it your argument here State Farm should have paid the 1.3?
My argument is that State Farm is the only entity that had the ability under the State Farm policy to make settlement decisions in this case. And that really goes...
But State Farm evaluated this early on and tendered policy limits. They knew that there was going to be liability in excess of policy limits, and they said, okay, these are the policy limits, we're going to tender those, correct?
Well, that's actually a great point, Your Honor. That's not entirely correct. And one thing that I think is actually getting glossed over in this case, and this was conceded by State Farm's counsel at the trial court level, before litigation was even initiated in this case, State Farm rejected a policy limit settlement offer that was made by Mr. Lightfoot to settle Mr. Lightfoot's claims against Ms. Hunt for the $50,000 policy limit. And State Farm rejected that offer.
So you're telling us we're going to see all of y'all again?
I'm sorry?
We're going to see all of y'all again in here.
There'll be a sequel?
I can't speak to, what's
Okay,
going to
go
come
ahead
down
with
the
your
road.
argument.
but-
We got you off track.
Yeah. But that's an important point, is that, and this goes to more the at our request language that Mr. Shaw was just speaking about. To the extent, it's important to keep in mind that State Farm did reject a policy limit settlement offer that resulted in this entire litigation in the first place. But that goes to the at our request language in the policy. And just to backtrack a little bit, I know there was a procedural argument that was made with regard to Florida Statute 627.4136. And it's our position that just under the plain language of that statute, it expressly allows for the joinder of insurers to final judgments unless one of two things occurs. The insurer denies coverage under the Claims Administration statute or defends under a reservation of rights under that statute. It's undisputed that neither of those occurred in this case. So just based on the plain language of 627.4136, joinder was proper. And if there are no questions on that procedural issue, I'll move forward to the coverage issue, which is whether State Farm's policy provides coverage for the fee judgment that was entered against Ms. Hunt. And it's our position that State Farm provides coverage under two separate provisions in the policy, and Mr. Shaw discussed each of them briefly. The first one is what I'll call the court costs provision, and that states that in addition to the limits of liability, we, State Farm, will pay for an insured any costs listed below resulting from such accident, court costs of any suit for damages. Now, so the question here is whether court costs includes a fee judgment entered pursuant to the offer of judgment statute. And the 5th District answered this exact question in the Hollingsworth case. That was Geico versus Hollingsworth. And in Hollingsworth, the court was assessing that exact term, court costs, and whether court costs included fees awarded pursuant to the offer of judgment statute. And the Hollingsworth court said yes, and it noted that there was no definition within the policy. In that case, it was a Geico policy, but the Geico policy did not define court costs. The court noted that if the insurer wanted to, it could have provided a definition of court costs that specifically excluded attorney's fees entered pursuant to the offer of judgment statute, and it did not do so. That's the same thing that happened here. State Farm's policy, it contains that same term, court costs, does not define court costs. It could have defined court costs to specifically exclude fee judgments entered pursuant to the offer of judgment statute. It did not do so. That's the same as in Hollingsworth, and the Supreme Court in Macedo cited approvingly.
Are you kind of putting an insurance company in a catch-22 if you are going to raise that argument when we have various statutes which specifically state you may receive attorney's fees as costs? So if you're drafting that policy language and you know that there are a sprinkling of statutes out there that specifically say in certain circumstances we declare fees as under the category of costs, how do you write a policy that takes that into account? So aren't you putting the insurance company in a catch-22 by saying you have to have this, uniform definition that says costs do not include fees? Unless a statute says otherwise?
Well, there are certainly, and I understand this isn't part of the record, but there are certainly insurance policies that do specifically exclude attorney's fees from the definition of court costs. Of course, that's not in the record here.
Well, it would be invalid if it
this-
was contrary to statute, though.
Well, and it sounds like, Your Honor, maybe kind of alluding to the Spiegel case, which had made that point that unless the statute specifically includes attorney's fees and costs, and that's contradicted by the Macedo case, where the court affirmed, well, first this court affirmed the joinder of an insurer to a fee judgment entered against the insured, and then the Supreme Court approved that. And
that case was from our court, and I know it went up, but in that case, do you concede that it wasn't the specific issue that we're addressing now? In that case, it really dealt with there being a request or a part of the insurance company in deciding whether the litigation went forward, I guess.
Well, part of the issue was whether court costs could include legal expenses, and there the court affirmed joinder of the insurer to a judgment that was for fees,
Right,
even
but
though the offer of
but-
judgment.
Right, but specifically because the insurance company had forced the litigation.
That was certainly an element of that decision, and as I noted earlier, that was also the case in this case, which it's a fact that I think is being glossed over here. The insurance company rejected a policy limit.
That's an important point. and
Policy limit
that's-
settlement
I'm
offer.
glad
So,
you
again,
brought
that goes-
that to our attention.
That goes to the at our request language, and I'll move ahead to that provision. Again, it's important to note here that this court can affirm if the fee judgment entered against Mrs. Hunt is covered under either provision in the policy, that court cost provision or this other provision, which states that State Farm will pay reasonable expenses incurred by an insured at our request. Now, it's State Farm's position that the at our request language only applies when there is a proposal for settlement within the policy limits. And no court has ever held that that is a rule. And in fact, this court in the Gray case, in interpreting that same language, quote, at our request, came to the exact opposite conclusion. In the Gray case, it was a cost judgment in that case, but the court was interpreting whether the insurer, whether that at our request language. And in the Gray case, there was no proposal for settlement within policy limits, but this court still held that the cost judgment was incurred, quote, at the request of the insurer because it was the insurer who controlled the litigation and controlled settlement decisions in the case. And that is undisputed here, that State Farm is the one who controlled settlement decisions as a liability insurer and under the plain language of the policy. And that's the same as the insurers in the Hollingsworth case, in the Gray case, in the Macedo case. In all those cases, it's the insurer who controls settlement decisions, and there's zero record evidence that State Farm ever relinquished that control that it had over settlement decisions under the policy to Mrs. Hunt. There's zero record evidence that that occurred.
Where in the record in either of these two cases do we have the information you've talked about today where there was a rejection of a policy limit settlement?
There was a concession at the trial court level by State Farm's counsel at the hearing.
You know the record?
Yes, I have a record set for you just a moment, Your Honor.
Well, I don't want to use
7841-42, where State Farm's counsel stated, I acknowledge there were pre-suit policy limit settlement offers within limits.
Thank
And
you.
those are policy limit settlement offers from Mr. Lightfoot to State Farm or Ms. Hunt.
Thank you.
Yes. So just kind of to summarize here, the procedurally plain language of the statute, joinder of the insurer was permissible, and under either provision, either the court cost provision or the reasonable expenses incurred at our request, under Macedo, Gray, Hollingsworth, the fee judgment entered against Mrs. Hunt is covered under State Farm's policy. And we ask that this court affirm the joinder of State Farm to the fee judgment. Thank you.
Thank you.
May it please the court, on behalf of appellee James Lightfoot, we join in the argument of Ms. Hunt, State Farm's insured. I would also point the court to the record at page 7204, where plaintiff specifically stated that State Farm had the discretion to settle this case 3 times for the $50,000 in policy limits before a lawsuit was filed, and then for the amount proposed in the proposal for settlement. And again, as 7842, the carrier did not accept the PFS, but I acknowledge that pre-suit there were policy limit offers within the limits. So that is, again, another record site. We ask this court to affirm the trial court's judgment. Thank you.
Thank you. Okay, let's give appellant a minute 30 total, please.
Thank you, Your Honor. May it please the court. I want to answer Judge Thomas's question because it's important. The question of whether or not State Farm should incur liability because it didn't accept a pre-suit settlement offer, as the court referenced, he wasn't in a motorized wheelchair at that point. He was walking around after the accident. Whether or not my client is liable for the fees as a result of not accepting a pre-suit settlement offer is to be determined in a bad faith action, and there's in fact one of those pending right now. The inquiry about what's in the record, what factual information is in the record about pre-suit settlement offers and so forth, my client didn't have the ability to take discovery in this case. So to the extent that those factual determinants matter, due process requires that my client be allowed to take discovery, and that's why a disputed coverage issue should not be resolved on this post-trial motion.
So your argument is the plaintiff should have brought you in to join you initially?
No, my argument is that we're comparing apples and oranges. When we talk about is my client liable for the fees awarded for not accepting the $1.3 million proposal for settlement, and that's why the fees were awarded, not because of anything that happened pre-suit. That turns on Macedo. That turns on the interpretation of the policy language. No court has ever held that something that a different offer other than the proposal for settlement could trigger a fee award that's covered under the policy.
So is it your position that's irrelevant to analysis under the policy language about whether you're involved in the litigation decisions, whether litigation is going forward because of your prior acts? Is that not a consideration?
If it is, my client should be allowed to take discovery and depositions and try to resolve that factual issue. I think it's a legal determination. Under Macedo, they treated it as a legal determination. Who had the right to accept this settlement, not what were the deliberations between the insured and insurer. Those factual inquiries are appropriate in a bad faith action, but with all the due process protections of discovery and cross motions for summary judgment, not on this post-trial motion that adds my client to a $1.2 million judgment and that didn't have the opportunity to defend itself factually against those assertions.
That'll go to whether you're liable for $11.5 million.
They would decide that as well, but the $11.5 million, the excess judgment and any amount awarded as fees could be recoverable in a bad faith action, but you have to show that it was bad faith not to accept that initial offer. We don't know, it's not on the record what information had been given to State Farm about his injuries at that point and so forth. So thank you, Your Honors.
Thank you all for your arguments. Court is in recess.
All rise.